So thank you again for being here. I'm Nora Mbagathi. I'm the Executive Director of Katiba Institute, based here in Kenya. We'll be hearing about 3 case studies today. We'll have representatives speaking on the Mau Mau case, which was filed in 2009 in the UK by the survivors from Kenya's Mau Mau resistance movement against the UK government for crimes committed during colonial times. We'll talk about the Métis case, which was filed by Métis Congolese women, which is the term for mixed race children born to African mothers and European fathers during the Belgian colonial rule in Congo, Rwanda, and Burundi, which was brought in 2018. And finally, we'll also be delving into a class action lawsuit in the US by Herero and Nama descendants against Germany for the mass killings, forced displacements, and internment committed against those groups between 1904 and 1908 in what constitutes the first genocide of the 20th century. And so these are the case studies that we'll be delving into, but it's very much also an opportunity to talk through how do these cases relate to each other, how do they relate to the broader movement, and again, how can we use the law in this? So to my left, we have Honorable Paul Muite, a senior counsel here who will speak to the Mau Mau case. We have Jehosheba Bennett with Juice Kogans in Belgium, who will give us some insights on the Métis children case as well. We have Patrick Kauta from CDH law firm in Namibia, who will also be speaking to the Herero and Nama case. And we have Melissa Hendrickse from Amnesty International to give us some of that broader context as well. And we will aim to have a proper conversation with you in the audience, to have a Q&A session. I would in fact love it if we were all sort of more circular and more together, but let's imagine that we are. But we will also be having a brief intermission where we'll have a poem as well, presented by Keith Rees, a Namibian poet, who will be presenting a poem entitled "Who Did You Leave Under the Sea?" So that's something to look forward to. But with that, I will actually hand it over and invite Mr. Paul, if you could speak a bit to your experiences in the Mau Mau case, please, and what lessons you've learned from that.
Thank you very much, Nora. A little favor that Her Majesty's High Court of Justice had extended to the Mau Mau case was allowing hearing dates to be fixed only during summer because of the advanced ages of the plaintiffs. And so we explained to them that they don't need to fear about the weather in London. But our pleas to our clients fell on deaf ears. So we went in the middle of summer, and the British media had a field day. The television and the print media, that it was stinking hot in that courtroom. But it wasn't hot enough for the Kenyans. Height of summer. But our clients were dressed with the huge overcoats, with the pullovers up to here, everything, and kofias, dressed for winter, because they had not understood how it could not be cold in England. But we went on very well. Let me begin my short or brief contribution by thanking the organizers of this forum for taking up an issue that is passionate to many of us, reparations, and doing it by balancing good fun, very well done. In fact, when you say Wakati Wetu, I fully appreciate, because this is not the sort of arrangements that our generation was used to. So you are balancing it very well, but nothing is more important than reparation. Let me say that from the Mau Mau case, above the issue of compensation for the torture, for the humiliations, for the detentions, one of the issues we wanted to hammer during that case was the recovering and restoring the humanity of the Mau Mau individual. Because one does not need to have gone to university or to school to recognize an injustice. And the colonial administration committed atrocities apart from the detentions and the torture. The original injustice was grabbing of the lands that belonged to the Mau Mau and their ancestors. Their fertile lands were grabbed by the colonial white settlers, and the original owners were turned into squatters on what used to be their own land. They recognized that as an injustice. So even long before the Mau Mau War broke out, the real reason why the Kikuyu Central Association came up with a petition that they pleaded with Jomo Kenyatta to take to His Majesty King George V was because the Kikuyu Central Association believed, naively, if you are to ask me, that the king could not possibly be aware of what his subjects had done here, grabbing land and turning the owners into squatters. That is a petition that Kenyatta was requested to take to the king. That is the first injustice. The second injustice was when the Mau Mau War broke out. And it broke out because all their efforts to get back their land were not being successful. So the whole thing in the war broke out. And Britain responded with horrendous atrocities, torture, killings, detentions. They were all there. That was the second major and monstrous injustice. And therefore, one of the points I would like to share is that in order for at least the Mau Mau case to succeed, and I suspect many other cases about reparation, the starting point is research in terms of accurate record on who was who in Mau Mau, who did what with their names. Because it's not just about those who were detained, it is about also those who were in the forests fighting for freedom. It's about the women, courageous women, who were cooking for the Mau Mau, because if you don't feed your army, they cannot carry on. So what this forum, in my view, should do is to begin, at any rate with regard to Kenya, to come up with a report that will contain accurate information on who was who in the Mau Mau War, who was in the forest, who was detained, and it wasn't 70,000. The more accurate figure is a figure of between 200,000 and 300,000. Let us have names to those people. Let's not talk in generalities. And let us at least push in order for them to recover their humanity, that they were fighting for justice. They were not terrorists. They were patriots, human rights patriots. At least it will not cost a lot to have a wall of honor with all their names. That recognition is very, very important. When Britain agreed to resolve this case out of court and we were negotiating, we told them that besides the monetary compensation, the one thing we demanded was an apology for the atrocities that we are committed. And it is important because that's how you restore the humanity of these people. We had a lot of quarrel. I remember them saying that that Britain has never apologized to anybody in history and they were not going to apologize. But eventually they came up with a form of an apology which they read on the floor of the House of Commons. Trying to sue for reparations requires a lot of diplomacy because apart from the reparation, and we were lucky in having the Kenya Human Rights Commission doing the preparations, going around the country talking to the victims. And here you are trying to talk to victims, you're trying to persuade them to talk about atrocities they had buried for many decades. It was easy at all, it was a very, very difficult task. But they did it. Now what is required is that sort of comprehensive, credible, comprehensive report so that you include everybody. One of the challenges which needs to be mentioned is that after the first betrayal by the colonial masters, after the second betrayal of the atrocities and the detentions and the torture and the killings, the third betrayal came from those who took over power from the colonial masters. They did not want to hear about Mau Mau, about the freedom fighters. These are issues that this forum needs to be aware of. I myself, for example, discovered when we are researching now in preparation for the Mau Mau case in London, that the Colonial Societies Act that had been preserved by the Lancaster House Constitution in 1963, so as to give independent Kenya time to come up with its own Societies Act. And that is the colonial legislation under which Mau Mau had been proscribed as a terrorist organization. Kenya's first Societies Act under independent Kenya was enacted in 1968. And I discovered during these preparations that in 1968, 5 years after Kenya had become independent, when we enacted our own Societies Act, the government of the first president, Mzee Jomo Kenyatta, re-gazetted in 1968 Mau Mau as a terrorist organization. These are the betrayals that I'm talking about. We were lucky that we had good witnesses in their 90s, still very clear-minded. And therefore, when Her Majesty's QC in open court in the High Court of Justice in England was questioning one of our witnesses, Wambogo Nyingi, who died about 2-3 years ago, as to why they were bringing this case 60 years after the events complained of. The court has got power to extend time for the filing of this sort of case, which is what we were relying on. But Wabogo Nyinge gave a very good answer. And he said, we are not late at all. Don't you know that Kenyatta was worse? And he was pointing at the QC. Kenyatta was worse than you, colonialists. And we only got light. The Gazette notice that declared Mau Mau a terrorist organization was only repealed, which is true, in 2003 when Mwai Kibaki took over. But it had been reinstated by Mzee Jomo Kenyatta in 1968. And therefore, before that time, we couldn't possibly file a case. How does a terrorist organization file a case? We were only able to file it when that Gazette notice was repealed. But it was good. And he was asked on the issue, these are some of the challenges we are facing, but why are you suing Her Majesty's government? It is your own people who were beating you. You know, the home guards are the ones who did the beatings, not Her Majesty's people. And Wabogo Nyinge was getting worked up. And he asked the judge, the English judge, can I be permitted to ask this man a question? The judge said, you cannot ask him a question, the practice, the ethics in law. But tell me the question you wanted to ask him so that I can ask him on your behalf. This is a judge. And Wabogo Nyinge said, I wanted to ask him, those home guards that he's talking about, does he know they used to wear a kofia? The QC was arguing the issue of agents. And that kofia had a crown here. I want him to tell us whose crown that was. And the issue of agency, I could see from the judge's body language that issue had disappeared. So we agreed to settle the matter out of court. We had sued in the names of 5 people, but because of the constraints of time, the case focused on those Mau Mau survivors who were still alive and who were able to prove evidence of torture through medical examination. And therefore, the people who got compensated were about 5,000. And we would like every person who was involved in this war of Mau Mau to get recognition and to be compensated. That can only begin to be considered, in my view, with a report that you can do. You will need to negotiate, obviously, with the government, but there are things you can do even without involving the government. An exhaustive, complete report. There was a small memorial constructed by the British at their own cost at Freedom Corner in Uhuru Park. But I believe myself, what is needed, if we get an exhaustive, accurate list of everybody who was involved, is a wall of honor with the names of each person with a line on what their contribution was, including the women that I mentioned that were cooking. I discovered also for the first time that although maybe 80-85% of the Mau Mau veterans were from Kikuyu, Embu, and Meru Association, there was at least 1 or 2 or 3 Mau Mau members from every ethnic community of the Republic of Kenya. There were individuals from Pokot, individuals from Kisii, from everywhere. And their humanity needs to have recognition in a word of honor, even as we go to discuss about monetary compensation. And the monetary compensation cannot be confined 60 years after independence to the former colonial masters. The Kenya government, the independent governments of independent states on the continent of Africa, need to show commitment and to show the way by contributing. If the compensation is 10 shillings, and we are asking the former colonial master to pay 8 shillings, the Kenya government should pay 2 shillings, because they too have got a responsibility, particularly on the land issue, that nobody stops them from addressing. Reparation is great. Do not let that issue to die or to be buried. And by organizing this forum, you are ensuring that the issue is not getting buried. Keep it in the limelight, keep the spotlight there until the governments of independent African nations actually address the issue of reparation, both with regard to land and to compensation. Because what happened at independence, the new African leaders stepped into the shoes of the former colonial masters and continued with that exploitation. That continues as far as my motherland is concerned. That continues to this day. So there are two divides of those who have and those who haven't. I can see you are looking at me. I'll stop there.
But thank you so much. You spoke incredibly powerfully, and I'm sure we'll have a chance to discuss that a bit more. I think you spoke extremely powerfully on the issue of the 3 betrayals and the need to restore humanity and what needs to be done beyond monetary compensation as well. Just one practical note, sorry, before we move on, which is that the session will actually take place both in English and in French, so you can have translation devices as well available if you require them, if you don't speak both languages. So thank you again, Paul, for your insights on the case. We'll have a chance to discuss that more, but for now I'll hand it over to Jehosheba that she can talk a bit about the Métis case and her experience as well. Thank you.
Thank you, Nora. I will be speaking in French, so maybe the one needing this. So maybe I start already?
Yeah. Channel 1, I think, is the English.
Yeah. Alors, je fais partie des avocates qui ont défendu les 5 femmes métisses congolaises qui ont attaqué l'État belge en crime contre l'humanité pour la manière dont elles ont été traitées durant leur enfance et d'ailleurs toute leur vie. Et donc, c'est une affaire que nous avons gagnée devant la Cour d'appel de Bruxelles en décembre 2024. Et donc, je vais faire un peu en 3 parties. Donc, d'abord, les faits, un peu revenir sur leur histoire et sur les faits, on va dire, les rétroactes un peu juridiques. Puis, je vais vous parler un peu des challenges qu'on a eus dans cette affaire. Et enfin, peut-être juste la stratégie et ce qui pourrait être utilisé éventuellement dans d'autres affaires. Alors, ces femmes, quand elles sont venues nous voir en 2019, c'était la première fois qu'elles parlaient à quelqu'un, en dehors d'elles-mêmes, de ce qu'elles avaient vécu. Donc, c'est 5 femmes métisses congolaises qui ont été élevées à la mission catholique de Katende au Congo. Et donc, quand elles sont venues, elles avaient un dossier avec quelques documents éparses qu'elles avaient récupérés une dizaine d'années après, voire 20 ans, je pense, après l'indépendance. qu'elles avaient récupéré, elles s'étaient retournées à la mission catholique de Cathénée, elles avaient récupéré un peu ce qui restait, parce que les Belges en partant avaient pris les documents, on avait détruit une certaine partie. Et donc dans ces documents, on a vu qu'il y avait des courriers qui étaient échangés entre les sœurs de Cathénée et par exemple le gouverneur territorial, le procureur du district. Et dans ces courriers, en fait, il était fait référence à des décrets qui autorisaient les placements des métis dans ces missions catholiques. Donc c'était des métis qui étaient mis sous tutelle de l'État belge. Quand je dis métis, c'est des enfants de mère noire et de père blanc. Pas nécessairement de père belge, comme on a pu l'entendre, puisque une de nos clientes avait un père portugais. Mais systématiquement, on enlevait ces enfants métis à leur mère, noire donc. Donc le système il était organisé plus ou moins à 3 niveaux. C'est-à-dire qu'il y avait le recueil, donc le RUFA, c'est le recueil à l'usage des fonctionnaires et des agents territoriaux du Congo, qui enjoignait à tous les fonctionnaires, tous les coloniaux, dès qu'ils voyaient un enfant métis, de le reporter au procureur, au gouverneur, au district, de dire ici il y a tel enfant métis avec telle femme dans telle maison. Ensuite, quand cet enfant métis avait l'âge de marcher, qu'il n'était plus allaité, il était déféré à la tutelle de la colonie. Donc ça passait par des commissions de tutelle qui avaient les pleins pouvoirs pour décider que cet enfant était abandonné, même s'il ne l'était pas, il ne l'était jamais d'ailleurs. Et donc de là, ils décidaient que cet enfant était sous tutelle de la colonie. Et 3e niveau, ces enfants étaient emmenés dans ces missions catholiques qui étaient donc les tuteurs délégués de l'État belge. Et là, en fait, ces missions-là élevaient ces enfants. Alors, je vous expliquerai un peu plus après comment ils les élevaient. Mais donc, d'abord, la question, c'est pourquoi. Donc, pourquoi on enlevait les enfants métis à leur mère africaine? Alors, on a recherché un petit peu, on a trouvé... donc, il y avait des congrès à cette époque-là qui étaient organisés par plusieurs puissances coloniales, d'ailleurs, hein, pas que la Belgique, des congrès sur le problème des mulâtres, comme ils appelaient ça. Donc, je ne vais pas utiliser ce terme-là, puisque c'est un terme insultant. C'est un terme qui fait référence au croisement entre un âne et... enfin, une ânesse, plutôt, et un cheval. Mais donc, ils organisaient des congrès sur cette question, sur le problème des métis. Et en fait, pour eux, leur existence était un problème puisqu'elle floutait les barrières raciales. Et donc, en floutant les barrières raciales, cela mettait en danger la suprématie blanche et donc l'avenir de la colonisation. Donc ça, c'était ces termes-là qui étaient utilisés, c'était comme ça qu'ils adressaient le problème. Et qu'il ne faut surtout pas flouter les barrières raciales. Sinon, il n'y a plus la hiérarchie, on va dire, s'estompe. Et la deuxième grande raison, qui peut sembler complètement folle et irrationnelle, c'était la logique de la goutte de sang blanc. Donc on partait du principe que ces enfants, comme ils avaient un parent blanc, étaient plus intelligents, ou en tout cas allaient se croire plus intelligents s'ils ne l'étaient pas, et donc du coup ne supporteraient pas la domination, la suprématie blanche qui était imposée, et donc en restant dans leur famille noire, allaient mettre un danger, encore une fois, sur la colonisation, puisqu'ils allaient créer des révoltes, en fait, en ne tolérant pas d'être dominés, contrairement aux Noirs qui, eux, évidemment, enfin, en tout cas pour les Belges, le toléraient bien. Eux n'allaient pas le tolérer parce qu'ils avaient cette goutte de sang blanc. Et il y avait cette idée aussi que c'était des éléments perturbateurs. Donc il disait, donc ça c'était un ministre belge qui avait dit Dieu a fait l'homme noir et l'homme blanc et le diable a fait le métis. Et il pensait aussi que ces éléments donc perturbateurs, donc il y avait eu de ce qu'il pensait, en tout cas, c'était un mythe qui se racontait entre puissances coloniales, cet Indien métis sur le Mississippi qui avait créé une révolte, qui avait tué beaucoup de blancs états-uniens. Et donc il y avait un peu cette idée, voilà, que c'était des éléments dangereux, perturbateurs, qui ne toléreraient pas la domination. Et donc il fallait à tout prix éviter leur création. Donc ça encore, c'est un ministre qui a dit « Aucun remède n'est trop radical pour éviter la création de métis. » Et ensuite, une fois qu'ils étaient créés, il fallait absolument les déraciner. Il fallait les enlever de leur milieu pour en faire, je cite, donc ça c'était le gouverneur territorial du Congo en 1940, non, le gouverneur du Congo, pardon, du Congo belge, qui dit pour en faire une classe intermédiaire de subalternes indispensables. Donc, Nos clientes ont été enlevées vers leurs 3-4 ans, donc comme j'ai dit, dès qu'elles étaient sevrées, qu'elles pouvaient marcher, et aussi parce qu'avant ça, il y avait des trop grands risques de mortalité. Elles étaient emmenées à la commission de tutelle ou non, il y avait juste un fonctionnaire qui disait voilà, là il y a tel enfant, et puis la commission de tutelle lui donnait un papier pour pouvoir transférer cet enfant dans une mission donc c'était soit avec la force publique, soit avec la police, soit avec justement un fonctionnaire blanc zélé qui voulait emmener cet enfant à une mission. Donc il y avait cette commission de tutelle qui avait le droit d'assimiler tout enfant métis. Donc ça c'est encore une fois écrit dans la loi, tout enfant métis peut être assimilable à un enfant orphelin, délaissé, abandonné, même s'il ne l'est pas. Et il y a un autre élément qui est important dans cette organisation, c'est qu'il faut savoir que les mères de nos clientes, pour 4 d'entre elles étaient âgées de 15 ans quand elles ont eu leur enfant. Donc c'était des très jeunes femmes, évidemment, qui, quand on leur enlève leurs enfants, qui à 3 ans, ne sont pas en capacité de s'opposer. De toute façon, elles étaient menacées. Donc, on menaçait de prendre, par exemple, leur frère, leur oncle, de l'emprisonner, de l'emmener à la guerre, ou parfois par des mesures, on va dire, de surprise, en tout cas en leur faisant signer des documents alors qu'elles ne savaient pas lire. Ou simplement en leur mentant, en leur disant oui, on va l'emmener là pour le mettre dans un registre et puis en fait ne le ramener jamais. Mais donc voilà, c'était des très jeunes femmes de 15 ans, c'était une pratique aussi qui était cette pratique de prendre une concubine de circonstance qu'ils appelaient ménagère était une pratique extrêmement courante belge, et donc il faut savoir que voilà, elles avaient 15 ans quand elles ont eu ces enfants, mais parfois ça faisait plusieurs années qu'elles étaient concubines de ces colons belges. Il y avait donc ces enfants et ces femmes, parce que certaines essayaient de cacher leurs enfants, donc leur mettaient de la suie sur le visage. Donc tout ça, c'est des choses qu'on a trouvées dans les archives, des femmes qui essayaient de se cacher, qui voyagent, alors que la mobilité n'était pas nécessairement facile à cette époque-là, et qui voyagent d'une province à une autre pour essayer de se cacher, des fonctionnaires qui les traquent. Enfin, c'est un enfer. Enfin, vraiment, elles vivent à ce moment-là un enfer. Et donc, dans notre citation, on demande, c'est une citation civile sur base, donc on demande réparation civile, donc indemnisation sur base d'une faute pénale constitutive de crime contre l'humanité. Cette faute, qui est un crime, pour nous, c'est de constater que la traque, l'enlèvement forcé, le placement, la ségrégation et la discrimination pour des raisons raciales sont constitutifs de crimes contre l'humanité. Donc c'est la base du droit de la responsabilité, c'est-à-dire faute, dommage, lien de causalité, réparation. Donc maintenant je passe au challenge. Donc un des challenges qu'on a eu, et une des difficultés qu'on a eu, c'était la prescription. La prescription parce que le crime contre l'humanité en droit belge n'a existé dans la loi belge qu'en 1999. Mais il y a quelque chose qu'il faut comprendre en droit international. Je sais que je ne dois pas parler de droit, mais bon, là, je pense que c'est important, et en réalité, tout le monde peut comprendre le droit si c'est expliqué clairement. En droit international, les États peuvent, en fait, s'auto-contraignent par le droit. C'est-à-dire que le droit international ne leur est pas applicable, sauf s'ils se sont autocontraints. Donc, comment ils peuvent s'autocontraindre ? Soit par un traité, soit par ce qu'on appelle la coutume internationale. Et la coutume internationale, c'est un État qui dit voilà, là je considère que ce que cet État a fait ici était illégal. Et bien après, par la suite, ça c'est du droit. Et ça, on peut lui opposer. Et donc, la Belgique, le 8 août 1945, a signé l'accord de Londres qui crée le tribunal de Nuremberg, enfin c'est le statut du tribunal de Nuremberg. Dans ce statut du tribunal de Nuremberg, il y a l'article 6C qui crée le crime contre l'humanité. Donc c'est la persécution pour des motifs politiques, raciaux, etc. La persécution de civils. Et donc, l'État belge, qui est parti au statut de Nuremberg, il accepte, il déclare, il se contraint en disant que le crime contre l'humanité existe. Dès 1945, il considère que la persécution politique de civils, enfin, pour des raisons raciales, c'est du droit. Et donc, nous, c'est des faits qui sont postérieurs à 1945. Mais donc, nous, ce qu'on dit, c'est, voilà, si l'État belge considère que ça, c'est du droit, quand ça concerne les faits commis par l'Allemagne nazie, qu'il est parti au statut Nuremberg, qui juge ces faits-là comme étant des crimes contre l'humanité, et dans le statut Nuremberg, il y avait évidemment la Shoah, le génocide, etc., mais il y avait d'autres choses. Il y avait notamment le fait d'enlever des enfants polonais à des familles polonaises pour les faire adopter par des familles aryennes allemandes. Ça, dans les procès Nuremberg, ça a été considéré comme un crime contre l'humanité. Donc c'est des faits similaires. Et donc, je vois qu'il reste 10 minutes et il y a encore 2 personnes, donc je vais me dépêcher. Donc ce que l'État belge nous dit, c'est que, ce que l'État belge a opposé comme argument, c'est de dire, oui, mais on a considéré que c'était des crimes contre l'humanité, mais c'était lié au contexte de la Deuxième Guerre mondiale et à ce que l'Allemagne nazie avait fait. Donc en fait, ce qu'ils sont en train de dire, ce qu'ils nous ont dit, c'était que des faits similaires, donc des mêmes faits commis en Afrique, n'étaient pas des crimes contre l'humanité. Donc à ce moment-là, l'argumentation, c'est de dire les Africains ne font pas partie de l'humanité. En tout cas, en 1946, en 1945 et jusqu'à aujourd'hui. Et le jugement en première instance a suivi cette argumentation en disant oui, effectivement, aujourd'hui, ce serait un crime contre l'humanité, mais à l'époque, non, c'était uniquement pour ce qui concernait les crimes de l'Allemagne nazie. Il y a... bon, ça, il ne reste pas beaucoup de temps, je ne vais pas vous parler de ça, mais donc, la Cour d'appel n'a évidemment pas suivi cette argumentation qui est profondément raciste et a dit que non, évidemment, que si la Belgique se contraint en estimant que le crime contre l'humanité existe et que ces faits-là sont constitutifs de crimes contre l'humanité en Europe, c'est la même chose en Afrique. Et d'ailleurs, les actes en question sont des actes qui étaient de toute façon punissables en droit commun, c'est-à-dire pas en droit international, mais en droit interne. Donc, l'enlèvement d'enfants âgés de moins de 7 ans, leur ségrégation, leur placement forcé, c'était constitutif de crimes dans le code pénal belge. Et donc, ce que nous dit la Cour d'appel, c'est que l'enlèvement d'enfants âgés de moins de 7 ans, commis par un État dans le cadre d'une politique systématique ciblant des enfants nés d'une mère noire et d'un père blanc, élevés par leur mère pour les séparer de leur milieu, uniquement en raison de leur origine, sont des actes inhumains de persécution réprimés par le droit international. Une autre difficulté qu'on a eue dans ce dossier, c'est la question de la preuve, parce que ces petits-enfants, quand ils arrivaient dans les missions catholiques, on changeait leur nom, on changeait leur date de naissance, mais heureusement, elles avaient récupéré à la mission de Katende un cahier que les sœurs tenaient, qui a été le registre des mulâtresses, donc le registre des Métis. Et dans ce cahier, il y avait leur nom, donc leur nom quand elles arrivent, le nom de leur mère, le nom de leur père, leur date de naissance, et puis en dessous, le nom qu'elles inventent de leur donner. Donc elles gardent le prénom et puis elles changent le nom de famille. Et donc, il y avait cette pratique de toute façon, le père blanc devait toujours apparaître dans leurs documents comme père inconnu. Le père n'était jamais inconnu. Tout le monde savait qui était le père. Il n'y avait pas d'inconnu. Mais la pratique, décidée par l'État belge, c'était de dire le père doit disparaître de la filiation. Donc, en fait,
Sorry, may I briefly interrupt just for timing reasons? If I can just flag, I'm hearing myself. Just to flag that I think we have a little bit less time, it seems, than initially intended for the overall panel. So I think if we can just move it along a little bit so that we can also get to the... Thank you so much.
Okay, but...
Still, no, please continue.
Okay.
Just so...
Okay, but I'm almost done. So, donc, on n'avait pas de documents réellement pour prouver, à part ce cahier écrit par les sœurs qui disait voilà. Mais heureusement, il y avait les noms des pères. Avec les noms des pères, on a eu accès, par contre, à eux, leur dossier de fonctionnaires dans les archives royales belges. Et de là, on a pu recouper avec les lieux de naissance de nos clientes. Et donc, parce qu'en fait, on était à un endroit où l'État belge, en première instance, niait tout. nier le fait qu'elles aient vécu ça, en fait nier absolument tout. Et donc on avait besoin de toutes sortes d'éléments pour prouver justement d'où elles venaient et qu'elles avaient réellement vécu ça. Mais comme une des choses qu'on reproche à l'État belge, c'est justement qu'elle n'ait pas que ce soit des enfants sous tutelle de l'État belge, néanmoins sans acte de naissance, sans dossier administratif, sans décision de placement, sans décision de la commission de tutelle, etc. Et donc, c'est à la fois on reproche ça, mais en même temps, on n'a pas les éléments pour le prouver. Et donc, d'avoir de l'autre côté l'État belge qui nous dit oui, bon, on n'en sait rien si elles l'ont vraiment vécu, c'est à la fois d'une mauvaise foi crasse, mais en plus, ça nous a mis en difficulté. Heureusement, ça n'a pas été suivi par les juges. Et donc, je vais passer la parole à mon confrère parce qu'il ne reste plus beaucoup de temps. Et on verra pour les questions-réponses après.
Thank you so much, and thank you also for framing that context of how the different status and the domination, the dominant relationship, how mixed race children were seen at the time, how that also impacted the case. And again, I hope we'll have some time. Can I just clarify this? Is this 5 minutes for the entirety? Because we started at 3:30, so it should be running for 90 minutes, which would be till 5. Well, okay, let's, in that case, maybe that can be clarified on... Okay, so do we have till 5 or? Oh, I see. Okay. Well, that's a bit unfortunate because it seems that then we won't have much time for the Q&A. But Patrick and Melissa, if you're able to speak maybe briefly, I'm really sorry that we have to cut it so short. But if you're able to speak a bit briefly, then maybe we can still fit in the poem and at least 2 questions, hopefully. Thank you.
Well, I mean, if it's that briefly, I'll just go to the point. We speak of the first 20th century genocide. We speak of a Herero and Nama genocide or extermination orders of 2 October 1904 and 23 April 1905. The difficulty, I think, relating to bringing these matters to court, I think Honorable Muite has eloquently spoke to it, relating to independent governments of the republics of Namibia and Kenya. The difficulty as well at international law is located in the principle of intertemporality. That is the principle of customary international law that says that basically says, and I have to go to it, that as a general proposition, international law does not permit retroactive application. The temporal sphere of any norm of public international law must be determined in accordance with a general principle of law by which any fact, action, or situation must be assessed in the light of the rules that are contemporaneous with it. So you go back to and this has been codified in the Vienna Convention on the Law of Treaties of 1969, Article 28. There's precedents. Those who have gone before us, the colonizers, made sure that the International Court of Justice in 1975, in the advisory opinion of the Western Sahara reports, interpreted that temporal doctrine accordingly. So in order for you to bring successful litigation against the former rulers, you will have to go through one or two of the exceptions. So the Namas and Hereros went to the US on the expropriation exception and claim.
Can you explain what that exception is?
That is an exception where they claimed that the taking of the property, that's land, taxation, customs, precious gems, labor, body parts, was against international law. If I come across as a lawyer the exceptions on the jus cogens, Melissa will explain them. I live in courts, as it were. And of course, that is the Nama and Herero case, both cases in the US. Of course, Germany was able to argue, and correctly so, on that exception, that there was no violation of international law, because if you look at the time, both the Hereros and Namas were subjects of Germany, because the territory then that they occupied then, that's currently known as Namibia, was subject to the German Reich, and therefore their law applied, and they could do as they wish. So Germany successfully claimed foreign immunity in the US based on the Foreign Immunity Act of the US. So after that, issues had advanced a bit. This judgment came out in the Hereros and Namas lost in the US in around 2020. The final judgment was around 2020. In 2021, the following a unanimous parliamentary motion to seek an apology and a confirmation that the events of that the acts of the German Reich was genocide, and that therefore reparations must be paid. Both the German government and the Namibian executive branch had concluded a joint declaration in which they agreed that the events are only genocide if you look at it with the lenses of today, with the law of today. Of course, that's an admission of the intertemporal laws, and therefore only development aid must be paid. The communities themselves, both the German and Nama communities, were excluded from these negotiations because, as the argument advanced, was that they were represented by the Namibian executive. We were able to look at that joint declaration and to try and fashion a remedy, and we did that looking at with a long-term view on one of the exceptions, which is the tort exception. But we had to be careful not to include Germany up front, because we knew that up front we decided to go to local courts and start review processes as a tactical remedy to set aside the joint declaration, basically on three bases. That it was the executive had no mandate to negotiate on behalf of both communities, and that the joint declaration was contrary to it was contrary to Article 63 of the Namibian Constitution that mandates both Parliament and the executive to assist the communities and not enter the and conclude and not conclude a joint an agreement that does not have their consent. So we knew doing that will give us access to the record. Okay, so we got the record, and then after getting the record, we are now in the process of getting Germany to account before the Namibian courts. That's basically where we are.
Thank you. Thank you so much, and thank you for. I realize it's very difficult to pull that together so briefly, and I think you really highlighted that point about how the involvement of independent governments and sort of them speaking for those communities also can impact these kinds of cases. Melissa, maybe I can turn to you to just sort of summarize and take a few of the highlights that you've heard from this today, very briefly, unfortunately. Because we have less time than we anticipated.
Yeah, no problem. I just want to make sure, will we still have time for the...
So I'm hoping that what we will do is, our hope was to do the poem and then go into the Q&A after that. I think what we might do is see if we can get a couple of questions, especially if there's impacted communities here who would like to ask questions or specifically, engage on how we... how one can use the law in these contexts. And also just to flag, I think everyone would be very happy to speak after this individually as well. But if we can take two questions, and again, I would prioritize any impacted community members that would like to ask questions, and then we will end with a poem after that, and then hopefully we'll wrap up.
Okay, I'll cede as much of my time as possible to the Q&A session then. But I think what all of the interventions of the panelists has made clear is there are, deep complexities in litigating reparations claims in courts, particularly using, international law as your framework, given that international law itself was so implicated in both the enslavement and the colonization of African people. And so, one of the challenges I think that came through both in Jehosheba's intervention as well as Patrick's is the invocation by colonial masters of the intertemporal principle. And Patrick has kindly explained that so that I don't have to. But I just want to kind of, I think it's a lesson that we don't treat that principle as infallible. I think in the case of Belgium, the Brussels court itself was open to kind of interrogating the point at which the prohibition on crimes against humanity crystallized under international law, meaning it became a recognized principle. And I think the other important thing to look at is this notion of international law being synonymous with European law. The thing with customary international law, it's comprised of both kind of state practice as well as an opinio juris. In other words, kind of the understanding by states that these are binding principles and that they're obliged to follow. And when European states, former colonial powers, are arguing that international law at the time did not prohibit either the enslavement. Did not prohibit the enslavement of Africans or the colonization or the genocide of African people, that it's really European law that they're considering. And there's kind of an implicit assumption within that assessment of what constitutes international law that African nations, polities didn't qualify as subjects of international law. And I think the intervention that was made by the keynote speaker, Yvonne, was really important in inviting us to kind of excavate. I think that this kind of imperative of excavation is also important in relation to international law. And you have legal scholars doing that work of excavating basically the archive and looking at actually pre-colonial African law, pre-colonial African international law, as well as African domestic law. And in many instances, we're finding that there was a refusal and a rejection of, the unlawful acts or the wrongful acts within those legal systems. And so I think an important question to ask is when we're turning to international law is whose international law are we referring to, and what are the kind of credible sources of international law that we consider? And I mean, even in the case of the Belgian court case, there obviously you have the Nuremberg Charter, but there are earlier documents as well that demonstrate in that case that the crimes against humanity prohibition was crystallized a lot earlier than one thinks. And in the case of Germany, there we have the Blue Books in the beginning of the 20th century, which also document the unlawfulness of Germany's conduct. So I think the question of archives, the question of kind of whose international law is incredibly important to litigation. I'll stop.
Thank you so much for that insight, and also for framing the ways in which the law that is being applied to assess these cases impacts the outcome of these cases. So I'll turn now to you in the audience and see if there's maybe any, especially may I first invite impacted community members to raise their hands if there's any questions from... Yes, okay, I see. Maybe we can start on that side. We're still looking for impacted community. Four questions, great. Okay, so we'll do. If you ask good questions, maybe we'll get an extra one. So I think we can start with the woman in. And if you could introduce yourself and your name as well, that would be helpful. Thank you.
Bonjour, je suis Rachel Kapumbo de l'Association des enfants de Belge ici au Congo. Madame, désolée, ok. Vous avez parlé des 5 métis qui sont en Belgique. Pour informer les autres qui sont ici. Oui, je suis ici, je défends les enfants de Belges abandonnés au Congo. En dehors des 5 dames qui sont en Belgique, qui ont porté plainte contre la Belgique, il y en a plusieurs au Congo, dont je suis la représentante. Et les 5... Alors, les 5 dames ont porté plainte. Vous avez gagné un appel. Et la Belgique est en train de continuer avec la politique du tombeau, je peux dire. Ils ont ramené les procès en cassation. Nous sommes ici pour demander à nos frères africains, les avocats africains, s'ils peuvent nous soutenir pour aller en justice contre l'État belge. Il y a des milliers de métis coloniaux abandonnés au Congo. Ils ont arraché, moi je suis de la 2e génération, ma mère elle a été arrachée à l'âge de 3 ans, ramenée à l'internat. Elle n'a jamais connu son père, ni le nom de son père. Sa mère était décédée à cause de l'arrachement, arrachée à l'âge de 3 ans. Elle ne connaissait ni le nom de son père, et qui était sa maman. Restée, je ne sais pas, 15 ans, après l'indépendance, ils ont fermé l'orphelinat et ma mère ne savait pas où aller. Après quelques temps, elle apprend que sa maman, elle a été décédée. Elle était à l'abandon des hommes. Nous avons vécu la souffrance de cet abandon. Et nous demandons aujourd'hui à la Belgique de réparer. Nous demandons la justice et la dignité de Métis abandonnés au Congo. Merci beaucoup.
Thank you very much. We'll collect a few questions and comments and then turn back to the panelists. And if I may just ask also that we keep it rather brief, unfortunately, so that we can get more questions in. So, yes, please go ahead.
Yeah, thank you once again. My name is Mabos. I'm from Namibia, from the Nama descendant. I will not go in legal that our council has put across. I just want to emphasize, I hope there might be a question in that. One is that it's not that we have not tried to discuss with our own government, or our own government to stand with us, to sit on one side of the table or negotiate directly with Germany. We have tried multiple times. You know, litigation is a very expensive process, and you know, this type of case will take years. But we were left, there was no place else to go, rather than go to the independent place where we can get a fair judgment. We hope we'll get a fair judgment how many years from now on. So we don't want to come here and phrase our government as bad. We have tried with our government. That is one. Second is, I know that the joint declaration, if you read the joint declaration that is put on the table, and this is why earlier I was asking the AU guy, does AU have political will at head of states? Because Namibia is going to the AU and say we have finalized a reparation package for the Nama and over Herero. Yet, if you read and you look at the joint declaration, and I think most of the lawyers, Melissa, they have looked at it, it doesn't talk about reparations at all. Patrick mentioned that it's a development aid. So what does the AU do then? Because that's a development aid. And then there's a lot of other conditions that is not positive for a reparation deal. Thirdly, I want to say that we have been forced again through our government not wanting to sit down with us to go across the world. If you can think about, we went to the UN. The special rapporteurs of the UN wrote to the Namibian government and to the German government, criticizing them on the very same joint declaration, that Germany somehow half-heartedly accepting that they committed genocide, but legally are not taking the responsibility. Thirdly, what Yvonne was saying is very true. Today, that colonialism is continuing. Today, at the very heart, in the Great Namakwaland, in today's Namibia, then it was the Great Namakwaland, a German company is trying to set up a big green hydrogen project. And the very community on the very same land that was taken away from the Nama people during genocide, they are going to set it up on the very same land without the consent, without consultation with the Nama people. So I just want to highlight this because I know time is very short. Because this is a long history and we have so much to talk about, but
and hopefully we'll have a chance. Thank you so much. We'll have a chance to discuss separately as well. I saw there was one more question here in the front, I think, and then we'll. Oh, okay.
Okay, let me go then. Dr. Shaweko. Okay, thank you very much. Anastasia Wanjiku, we advocate for reparations here in Kenya for mine goes to Dr. Muite, sorry. I know you litigated for compensation in 2015 2015. Is it 2015, 2013? Okay, I wanted to know what led you to make a decision with the British government to do an out-of-court agreement. And then after that, what method did you use to pay the 5,000 people that you decided to pay with the little compensation that you settled out of court? Thank you.
Thank you. I think we have one.
Yeah.
Right. Sorry, could we also have a question from, I think we had a few on this side as well, and I'm very conscious that we've heard from this side a lot.
Thank you. My name is Dr. Ngasha Karani, and my main question is that already the OAU had already in their 27th meeting had authorized the states to research and ensure that what was taken away by the colonialists be returned 5 times. At that time, when our friend Mr. Muite, we have now agreed to a reasonable extent, although at the same time we differ, they did not go for Mau Mau. They went for home guards who were supporters of the colonial government in Kenya at its colonial time. And one of them, Mr. Getoka Hengeri, whose employment number in the Home Guards was 475 KB, meaning Kiabu, and they participated in the killing of thousands of Mau Mau people who had somehow been caught in the middle during the expatriation from Tanganyika to Kenya, being suspected being Mau Mau. So the research or the questioning of who was a Mau Mau was never done. The question was, they are Kikuyus and thus they must be eliminated. Mr. Muite, our good friend, you should reverse what you got because it was not worth being paid for people who had a lot of pain in what had been done. You remember, because you are from Mount Kenya, that homes, cattle, lands were confiscated by the order of the Queen. But that one was not actually covered at all. It is this time that we have pushed through the International Court of Justice, through Mr. Elik Kialo Mutua, who, after filing that in court, the British ambassador to Kenya, Edward Clay, admitted liability during the Kibaki time. And that is the same time when the Society Act Cap 108 was removed from the books which Kenyatta and his following president actually maintained, because they had an authority from the British to maintain the status quo, because Mau Mau had to be made perpetually poor. Please explain.
Thank you very much. Sorry, may I suggest that we take one more question from this side of the room, and then I'll hand it over.
Yeah. My name is Kimathi Nkrumah Abiko Makonnen. I want to ask my brother a question on the KLAF, Kenya Land and Freedom Army. Is Mau Mau a quotation of the British colonizers, or is it a word in Kikuyu or Agikuyu? Asante in advance.
Thank you. So I will hand it back to the panelists to both answer the questions that have been posed or comment on any of the comments that were made, and also in the same at the same time give your final remarks, please, because we won't have another chance to come back to you. So I'll just go down the row if that's okay. So I'll start with you, Honourable Paul.
Somebody commented about getting independent African governments. sitting at a table with the former colonial master. And I support that wholly. I don't think that compensation and reparations should depend on litigation alone. There should be a combination of politics or political power with litigation. Second point is that we do need, my friend from Namibia, we do need to go beyond in terms of research. That this is what international law says. We cannot allow colonial powers that committed unspeakable acts of atrocity, rapes, murder, what have you, to get away with the law they have crafted to protect themselves as the only applicable law. Torture is not permitted even under the UN Commission. So even as we litigate, let us develop strategies of persuading our governments to engage the former government. When we settled this case in England, the British government said it was anxious to have that issue of Mau Mau not being an issue anymore between Kenya and UK. And when we were discussing that, and it was in the statement they read on the floor of the House of Commons, we say compensation of 5,300 people does not resolve the Mau Mau issue. We would like a commission of inquiry jointly by Britain and Kenya. Mind you, the case in England, the Mau Mau case, had been initiated by Mau Mau in their capacity as Mau Mau. But an issue now of mounting a commission, it's an issue that needed the collaboration between the government of Kenya and the government of Britain. And they made it clear, Mau Mau cannot request for that wider commission of inquiry. Can you get the Kenya government to make that? I wrote a letter to the Attorney General, to the President, no response up to now. In other words, Britain was willing to join in a commission of inquiry to list all those people who are involved. It is our government that never made that request. So we settled this compensation. It was not an easy case. It was not a walk in the park. They made 2 applications to dismiss our case. It is when we succeeded in resisting those 2 separate applications to dismiss the case that they then say, let us sit down and negotiate. Each of these 5,300 people, each one of them received over 300,000 shillings, not from us, but from the British government, who are required to open their bank accounts, and the money was sent directly there. Mr. Karani Gacha, I don't want to go into controversies about who was who. Stated my position. I would look forward to a commission of inquiry to tell us who was who, an issue of who was who, a credible commission of inquiry. I wish you the best, and the International Court at least give a little credit that we succeeded to some extent. And as far as Getu Kahengeri is concerned, who is now close to 100 years old, as a 15 years old young son, he was detained with his own father, son and father, detained in Lamu. But I leave that to the Commission of Inquiry to find out whether he was a home guard. I have made the point that the worst betrayal was independent on the issue of land and lack of recognition of the Mau Mau.
There was one more question on the meaning of Mau Mau and where the word came from, whether that was a colonial term.
Mau Mau came from the British misunderstanding of the oaths that were being taken. You know, like when they would, whatever word for the oathing was taking place, the British did not quite understand. And they are the ones who started calling Mau Mau, Mau Mau. It is not the Mau Mau who came up with that word. It was the British. What the Mau Mau were doing was taking the oath in order to fight for their land and to fight for freedom. The original name was Land Freedom Army, that translated into Mau Mau around about 1948, when they started taking the oaths at Oleguruni, the young people, Kenyans, who went to fight with the British and discovered that these white people are actually human beings like us. Because the Kenyans discovered they were even braver than their white comrades.
Thank you. Thanks so much. Jehosheba, may I ask whether there's any... Yeah, thanks.
Maybe I answer in English if easier. Thanks for your remark about the Métis kid left in Congo. Actually, our clients were also abandoned in Congo. They arrived in Belgium. They were adults. And they had also to take lawyers to have the nationality. I mean, they were supposed all their childhood to be reunited in this mission because they were the children of the Belgians, but yet they had to, they came when being adults. And actually they were abandoned at the moment of the independence. So they were left there. Some of them were kids. They were in the middle of a war. They lived atrocities at that moment. Some of them were raped. They had to take care of babies, orphan babies, Congolese that were there, but they didn't know how to take care of them, what amount of milk to give them. So they had babies dying in the mission, and they were like 11, 10 years old. I mean, they lived really atrocities. So actually, the Belgian, in contrary to Rwanda, where they took the Métis kids in Belgium to have them adopted by Belgian families, in Congo they left all the Métis children. But this, we also, I wanted to talk to you about it before, but we didn't have the time, but it was also something that we aim as a wrong, as a fault in our procedure, but the judge didn't consider it as a crime against humanity. The crime was abduction, the segregation, etc., but not the fact that they abandoned them. What you told about your family and some of them that a mother that died because they took their children. I mean, it's the reality of it. Like the mother of some of our clients also died from disease of stress, anguish, because we take your kid and you never see it again. Of course, you can die from sadness and horror. And the tomb policy, la politique du tombeau, the fact that the Belgian state right now is going in cassation in Supreme Court and we still don't have a date right now. So it's been 1 year we have won, but the Belgian state is going to cassation, while in public medias, the Prime Minister, there is a parliamentary commission recognizing the atrocities, the crime against humanity, recognizing there has to be some reparation, of course not financial reparation, but moral reparation, whatever, how they say. And now that's what they're saying in public space, in medias and everything, but in court they have a totally different discourse, and they are withdrawing the little dignity it's staying to our client by not letting them win anything. They keep denying everything, and when we win, they keep going up and up to try to find something to not pay actually, because they will, if they win, it's to the five of them, it's more than 1 million. So it can be a lot of money. And one of the arguments of the Belgian state that wasn't a legal argument actually, but more of a political one in court, it was that, they were saying to the judge that they cannot give us rights because after there will be thousands of Métis asking for the same thing. And can you imagine the Belgian state will have to pay how many?
Yeah.
It's really a terrible argument. So I think.
I'm sorry to cut you short, but I would like to give one sentence maybe just to Patrick and Melissa as well, if they're able to. Thank you.
No, you go. It's fine. There were no questions for me, so take my sentence.
Oh, well, the only thing I can say is this is a topic that we can all agree needs more time and more greater discussion than we have had. So thank you for the invitation.
Thank you so much, and thank you everyone for attending, for engaging. I'm sorry we didn't have a chance to talk about this more, but I do hope that there can be continued conversations. And as was mentioned, this forum is just sort of the start of all this. So thank you so much. I think we learned a lot about how the law can be used, but also the way in which sort of the colonization of the law itself poses a challenge, about the political will and power that is needed, how independence governments have also caused some of these issues to continue, and whether there is political will at the regional level. And I think really interesting questions were raised around accountability and representation, right? Who is representing whom and in what context, and who is making which agreements on whose behalf. So I really hope that this panel is not the end of this conversation and that we'll have a chance to speak further on this. Thank you so much.